Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates. Today, we discuss about the procedural legal view, part 2 in criminal cases. Point 1 is Section 148 of BSCA Act 2023. Corresponding law is Section 145 of Indian Evidence Act. When it is intended to contradict a witness by his previous statement reduced in writing, the attention of such witness must be called to those parts of it which are to be used for the purpose of contradicting him before the writing can be used. Second point is, while recording the deposition of a witness, it becomes the duty of the trial court to ensure that the part of the police statement with which it is intended to contradict the witness is brought to the notice of the witness in his cross-examination. The attention of witness is drawn to that part, and this must reflect in his cross-examination by reproducing it. And point 3 is, this is the most important point here. If the witness admits the part intended to contradict him, it stands proved and there is no need to further proof of contradiction. Again, if the witness admits, important point here is, if the witness admits the part intended to contradict him, this is the key word, intended to contradict him, it stands proved and there is no need to further proof. This is also important here. There is no need to further proof of contradiction and it will be read while appreciating the evidence. Point 4 is, if he denies having made that part of the statement, his attention must be drawn to that statement and must be mentioned in the deposition.
Welcome. Result. By this process, the contradiction is merely brought on record, but it is yet to be proved. Thereafter, when IO is examined in the court, his attention should be drawn to the marked crime scene sketch for the purpose of contradiction. It will then be proved in the deposition of the IO, who again by referring to the police statement will depose about the witness having made that statement. The process again involves referring to the police statement and culling out that part with which the maker of the statement was intended to be contradicted. If the witness was not confronted with that part of the statement with which the defense wanted to contradict him, then the court cannot suo motu. Again, then the court cannot suo motu make use of statements to police not proved in compliance with the section 148 of BSA Act. Corresponding law section is 145 of Indian Evidence Act. That is, by drawing attention to the parts intended for contradiction. This video is purely theory. The Honorable Court decides each case on merits.
Thank you.